basic guarantee contained in that Constitution is the Due Process Clause, which I believe everybody is familiar with and which guarantees that no person shall be deprived of life, liberty, or property without due process of law. Pretty words, familiar words, but what do they mean, really? You are probably more familiar with the, You are probably more familiar with procedural due process, which is basically the right to be heard before you're judged. But there is a second aspect to the due process guarantee, which is substantive due process. And what that means is, by enshrining this principle and this guarantee in your Constitution, the government is tasked with a basic obligation of never acting in any manner except that which is rational and logical and that which is fair and not oppressive to its citizens. Let's consider how that plays in the field of interference with property rights. When is interference with property rights reasonable and not oppressive? Generally in two conditions. One, the party that proposes to interfere with your property rights has a judgment in his favor. That's easily understood. A court order says that in fact he is the rightful owner and not you, and so therefore you give up the property. Or that he has a lease and so therefore you give up use of the property. A valid lease. But there is also a second category, specially carved out, where there are emergencies that need to be addressed. And this is where you have the temporary restraining order or the preliminary injunction, which is nothing but an order meant to issue where there is a clear right demonstrated by the applicant that if the order is not issued, he will suffer irreparable damage in the premises. So the requirement for a reasonable interference with property rights, one defensible under the due process guarantee, is that the interferer should have a clear right and a showing that he will otherwise suffer irreparable injury if not aided by the court with a preliminary injunction or a temporary restraining order. Does this apply, and is this principle followed in the case of TEPOS? It is not. There is a very curious element that has been introduced into the rules for environmental cases that defines a so-called precautionary principle. And it says that when human activities may lead to threats of serious and irreversible damage to the environment that is scientifically plausible but uncertain, actions shall be taken to avoid or diminish that threat. It goes on further to say that when there is a lack of full scientific certainty in establishing a causal link between the human activity and the environmental effect, the court shall apply the precautionary principle in resolving the case before it. What does this mean simply? Well, if you look at the second bullet point, when it says there is a lack of full scientific certainty, what that means simply is that there is no factual reality that has been proved, because scientific certainty are just pretty words to mean what is factually real. So if you dispense with the requirement for a factual reality to justify the action, what you are saying actually is when the factual reality of the link between the human activity and the environmental effect is lacking, you must apply the precautionary principle and issue the temporary restraining order, in this case called a TEPO. So the effects, sorry, this is a hair trigger. The effects of the precautionary principle, and I ask you to concentrate on the third bullet point, is that it allows orders interfering with property rights to be issued on an admittedly baseless bias imposed by the so-called precautionary principle for the applicant, and not upon any scientific evidence or objective fact of environmental necessity. All that means is that the property owner is deprived of his property right without proof that the act complained of causes or even is likely to cause the damage it is claimed to engender. Oops, sorry. If you think about it, the true precautionary principle is the due process guarantee, because that establishes the fundamental rule of precaution for government action. It cautions government not to act except in a way that is reasonable and logical and fair and non-oppressive. That fundamental constitutional precautionary principle is violated by the false precautionary principle created by that rule in the environmental rules in the rules for environmental cases. So if you, like me, believe that the Constitution should apply to the mining industry and to environmental issues, then there is that question that arises as to whether or not the substantial due process clause does justify a reading that the insertion of the precautionary principle and the ability given to courts to issue orders without effectively a preponderance of evidence or a real showing of need on the part of the applicant is unconstitutional and void. So that's the first example, and I think, in fact, in considering that, you might be justified in asking yourselves why or if the Constitution does apply to the mining industry when you're talking about environmental cases filed against the industry. And the curious thing about it, of course, is that these are rules that have come from the Supreme Court. That is why it's all the more surprising and all the more concerning. Let's go to the second example, which is now something issued by the executive branch of government, which is, the EO 79. And the example I choose for this is the expansion of areas that are close to mining. As you know, EO 79 proposes to add several areas as areas closed for mining activity. Let us again begin with the basic social contract that we have with each other, the most fundamental expression of our deal with one another and our deal with the government that we have created, which is, for any constitutional democracy, the principle that is a system of allocated, limited powers, so that nobody runs roughshod over everybody else. And for the legislative, you all know that the Constitution says that legislative power is vested in Congress. Now, I draw your attention to the mining law and the matter of areas close to mining as defined by the mining law. If you look at Section 19 of the mining law, and I will not bother you with the details, I will just tell you that there is a limited list, and then there is a catch-all which says, plus other areas, quote, areas expressly prohibited by law. Now, that's very clear. That means that areas close to mining are those defined by the mining law and any other areas defined by further laws issued by Congress. So Congress must be the deciding agency as to the addition of areas to the list that it has defined initially or finally, depending on its disposition, in Section 19 of the mining law. But now let's consider what the EO 79 purports to do. It purports to expand that list in the mining law by adding several other areas, among them these. You can read them: private agricultural lands, fisheries, tourism areas, and surprisingly, a very, very wide list of so-called other critical areas, island ecosystems, and impact areas of mining that the DENR may identify. You will note that in all these items, the determining agency is a branch of the executive department. The decision of the executive department decides whether or not an area is added to the list defined by Congress and which Congress has said can be expanded only by law. So the first constitutional problem we face in this respect is that in fact there is a clear violation of the separation of powers, where a law passed by Congress contains a list and does not contain a further delegation of authority that says these items in my list plus any other items that Congress, that the executive or a particular branch of the executive may add. Because delegation of legislative power, as most of you probably know, is a valid exercise and decision that can be made by Congress. Under certain well-defined parameters, the delegation can be valid. In this case, there is not only no delegation, you have a specific reservation made by Congress that additional areas are only such areas as other laws will define. So again, in this case, you have what I think is a serious question regarding the constitutional validity of the attempt to add closed areas through an EO, which is not an issuance of Congress. That's not all. There is a second constitutional problem in this listing made by the EO, in that it contravenes a fundamental hierarchy of values or purposes defined by the Constitution. Under the Constitution, the activity of mining is given a preferred right over other activities to which land can be devoted. And that includes agriculture, fisheries, tourism, etc. We can all of us have individual issues with that hierarchy, but we all of us, in some way or the other, participated in ratifying that hierarchy when we voted for the adoption of this Constitution. And it's a deal we've made with each other, it's a deal we've made with government, it's an approach and a value judgment we have adopted, that mining is a primary or the primary activity if you have a set of alternative or optional or available activities to which to devote land for the realization of the value of your national patrimony and as the tool for achieving national progress. That decision has been made by you in your Constitution, by all of us. And I'm not the one saying it. It's the Supreme Court saying it in these two cases. And very quickly, the Supreme Court has said, once minerals are discovered in the land, whatever the use to which it is being devoted at the time, such use may be discontinued by the state to enable it to extract the minerals therein in the exercise of its sovereign prerogative. That means by the state through any party allowed or contracted with by the state, which is the mining company or applicant or partner. The land is thus converted into mineral land and may not be used by any private party, including the registered owner thereof. No clearer words have been spoken. Including for any other purpose, for example, agriculture, fisheries, or tourism, my insertion, just to clarify, that will impede the mining operations to be undertaken therein. And just so it's clear, mineral lands are outside the scope even of a program as important and as vital as agrarian reform, according, again, not to me, but your Supreme Court. If you believe that there is that basic hierarchy that has been defined by the Constitution as clarified by the Supreme Court, then we have a second constitutional problem with the expansion of areas close to mining by an EO issued by the executive. That's not all. There is yet a third constitutional problem with just this one item in the EO. I told you earlier that there were those three other areas, critical areas, island ecosystems, and I forget the third, but there was a third. The definitions presented by the IRR are, with all due respect, extremely vague, and at least to the best of my abilities to understand them, actually incomprehensible. Let us take up a sample definition of an island ecosystem or island ecosystems. The IRR says that this refers to terrestrial, inland water, and coastal marine environments in an oceanic island possessing unique but fragile and vulnerable ecosystems, where community of living organisms, plants, animals, microbes, in conjunction with the non-living components of their environment, are interacting as a system. The most critically important elements of that definition are unique and fragile and vulnerable ecosystem. I submit to you that those are meaningless. Look at the second phrase first. Let's take this in the reverse. Fragile and vulnerable ecosystem. That's everything. What ecosystem is not fragile or vulnerable? We have found out over the last 20 years, 10 years, that the entire globe is a very fragile ecosystem. That is why we have accepted that our role is as stewards of it. So to the extent that this would differentiate this type of ecosystem from robust and invulnerable systems, there is no such distinction. All systems are susceptible of a classification under this formula because all ecosystems are fragile and vulnerable. But you ask yourself, does the definition start to make sense when you consider the other qualifier, the other adjective, the other limiting factor, unique? No, it doesn't begin to make sense because unique is not defined. What does unique mean for an ecosystem? If, say, two ecosystems have a universe of 5 potential common characteristics, will the possession of 3 common characteristics make those ecosystems similar? Or does the absence of the remaining 2 make them dissimilar? Who knows? Unique is not defined. Now, for example, also, what does unique mean in the sense of, for example, Leyte or Bohol having the tarsier? Sorry, I don't know which one of them actually has it. But let's assume that it's Bohol that has the tarsier. Does that make Bohol unique because it has the tarsier? Or does that make Leyte unique because it doesn't have the tarsier? So, again, this is a definition put in there which I'm completely unable to understand. And I doubt, well, maybe most people are more intelligent than I am. I don't know how many other people can understand it, but my appreciation of this yardstick is that it can mean any, some, or all island ecosystems depending on the whim or caprice of the decision maker at the time. And that is not allowed by the due process standard because the due process standard requires rationality and logicality. That is not present when you have an incomprehensible rule that is supposed to be the instrument for governance. Because then you have a rule that is either incapable of enforcement because incomprehensible, or capable of any number of ways of enforcement in arbitrary and oppressive manners because, in fact, for the same reason, it is incomprehensible, and so therefore it can be claimed to apply to anything and everything. So, the constitutional consequence is that, again, for all these reasons, the attempt to add closed areas to mining for not 1, not 2, but 3 reasons, at least. I'm sure somebody who, well, okay, I'm not sure. Maybe somebody else who devotes more time thinking about this can come up with a 4th constitutional issue. But under our rules, you only need 1 constitutional flaw, and the measure is void. I think we have at least 3 flaws in this particular area. Let me just close by making you slightly more uncomfortable if that has not worked as yet. Let me tell you that there are similar other provisions in the executive order. Section 7, very quickly. Section 7 of the executive order imposes a moratorium on the issuance of new mineral agreements. Now, moratorium is another pretty euphemism. But if you think about it, moratorium says it's a suspension of enforcement of laws. And well, I don't mean anything impolite by this, but a refusal to implement or enforce laws. But the duty on the part of the executive branch, the entirety of the executive branch, is to enforce all laws. In fact, if you take a quick look at the oath that the chief executive takes before or upon the assumption of office, you will find that the oath requires the execution of all laws, and not just the laws that whichever executive administration finds pleasing for itself. Because the notion is that if your Congress, the representatives of the people, have decided that a certain measure should become law, that decision is the people's decision that it should be enforced. And so a refusal to enforce it, I think, is a constitutionally infirm step, because effectively it's like, a quiet, subtle, sub silentio way of actually amending or revoking that law or suspending that law, when in fact that is a call left for Congress. The next one, downgrading the exclusive right of holders of exploration permits under Section 24 of the mining law to mineral agreements or FTAAs to mere and undefined rights of first option. Again, it's the Congress that decided what kind of rights these parties will have. To say that those rights will be changed or replaced by anything. And here, it would be a flaw either way. The executive could increase those rights or the executive could decrease those rights. In whichever direction you go, it's still your direction and not the direction of Congress. And so there you have a valid issue as to whether or not legislative power has been executed by an entity or a party other than the one in which the Constitution reposed it. And finally, the Section 5 mandatory disqualification resulting from environmental incidents. The objectionable feature here is that not only is disqualification a new penalty imposed that is not otherwise available under the pre-existing laws, but it is imposed not only on the particular mining activity affected by the environmental incident, but on every other mining activity engaged in or proposed to be engaged in by a mining company otherwise compliant with all laws and regulations. And even, if I recall correctly, the activities of the owners of those mining companies. So you're expanding it even 1 degree upwards. Owners which may not have had anything to do with the particular incident. In fact, nobody could have had anything to do with the incident, which is another issue altogether, because we all know that environmental incidents can, of course, result from irresponsible, grossly negligent mining, but it also can result from responsible, conscientious mining in cases of force majeure, or the failure of third-party suppliers of services or equipment chosen in good faith after due diligence activities by the mining company. So that very premise of adding disqualification as a penalty where the laws do not have it is already questionable. But to go yet a step further, where you're saying not only are you disqualified from pursuing that activity that's affected, but every other activity you may have, notwithstanding that you're following all the laws that apply to all those other activities, and in fact, even if all those activities involve measures or methods of mining or geographical or topographical features completely different from the ones that caused or had some relevance to the environmental incident that occurred in the first site. That, I would submit to you, is another clear violation of the substantive due process requirement, which requires, as an element of reasonableness and logicality, some reasonable connection between the means adopted and the purpose sought to be achieved by the means. There is no relationship whatsoever between the purpose of forcing a mining company to clean up its act or to prevent the activities from further harming whatever is harmed in the first site, and the measure of stopping other productive, compliant activities elsewhere not involving anything similar to the activities or connected to the activities in the first site. So those are examples, I think, for why my question wasn't so silly after all. And I think it remains for the industry to consider these aspects or these matters of potential concern, and I guess to act in accordance with either its, well, obviously both its interests and the terms of the Constitution, which is supposed in any event to govern all of us, including our government. Thank you.
Thank you very much, M. It was certainly not a silly question. And now that we have been sufficiently disturbed, I will now call on two of my colleagues in the Legal Committee of the Chamber of Mines to offer their own perspectives. Attorney Marilyn Aquino, Assistant Director of First Pacific Company Limited, and Attorney Roderick Salazar, Managing Partner of Fortune Narvaza and Salazar.
Good afternoon. I thought that the mining industry is in deep shit when one of the main speakers is a litigator. So, but that's a good briefing because I think I can appreciate that when you talk about the fundamental rights, the Bill of Rights, it's not easy to grasp. It's your talking theories. For example, it's hard to understand moratorium on mining. Why is it objectionable? Maybe then you equate it with, can, for example, your government tell you, okay, let's have a moratorium on your Bill of Rights because we need to train the police because the police are inefficient and some of them are corrupt. So in the meantime, you don't have Bill of Rights. That's exactly the counterpart, no? That's putting it in clearer terms. So that's the challenge for the mining industry because we talk, in a sense, technical points. We need to bring to the people how, in the most practical way we can explain it. The IRR itself emphasizes the primacy of the Constitution and the national law as against local laws. Well, it's just unfortunate that even the IRR did not follow that mandate of emphasizing the primacy of the Constitution and the laws. I believe that there's no cause so great or important that can justify us disregard for the rule of law and the fundamental rights that's guaranteed to us by the Constitution. Because the rule of law and the fundamental rights and democracy, they're the foundations of an orderly society and the civilized world. And without those, no right, even the rights of the environmental groups, will be respected or can be expected to be guaranteed by anyone. So I think it's important when we focus on what Attorney Lombo said, that the Constitution itself gives primacy to the use of the land as mineral, or the exploitation of mineral resources, because of all the business activities, it is one activity that has, is in a sense of fiduciary. It is one activity which the Constitution somehow imposes a fiduciary duty on the state to develop, because all other business enterprises are simply business enterprises for the private sector. But exploitation and development of mineral resources of the state is not only a private enterprise, it is also an enterprise that is supposed to redound to the common good, to the people, the wealth of the nation to be used to help its people. And there's so much poverty around, and there seems to be no moral justification for us or for anyone to tell the state or even the mining companies to just let that wealth remain underground and don't use it because of all of these restrictions, because we prefer tourism, we prefer agriculture. What do we do? How do we explain that to the people, to our people, with so much poverty around us? So many people are born poor, in utter poverty, and they will die poor. Do we tell them to wait some more for the next generation to benefit from the wealth of the nation? How do we do that? And as a practical matter, look at the indigenous people. The indigenous people, they have been granted by the IPRA law the right to self-determination. They have the right to determine what activities must be undertaken in their ancestral land. Do we tell them that their ancestral lands will not be used for mineral resources and the wealth underneath the ancestral land will never be exploited and they should just be there and limit themselves to development of tourism and agriculture? What are we telling them? We're actually telling them we're taking back your right to self-determination, which you took so long to receive. It took so long for the state to give you the right to self-determination, and now the state is taking it back from you. And what does that mean also economically? You know, in every mining activity in ancestral domain, the indigenous people receive 1% gross royalty. They're actually partners in development of mineral resources. So you tell them, for example, what's the effect of telling them from now on, this ancestral land will not be used for mineral development. You use it for tourism, ecotourism. So do you have just deprived them of the 1% gross royalty, which they can use to help their people, alleviate the poverty, and help educate their people? Is that fair? What gives us the right to take away what the law has given them? And the other, on Section 9 of the IRR, I think it's one clear case where you don't have to theorize, you don't have to argue. The deprivation is very clear. We have just been deprived of the next 25 years of our contracts. The law guarantees us 50 years, 25 years, renewable for another 25 years, under the same terms and conditions. The IRR tells us that the next 25 years will be negotiated, will be subject to terms and conditions that will be negotiated with the government. That actually shortens our contracts to 25 years. And that will be priced by the market. And if you have borrowed money on those contracts, you are probably in danger of having a default because your contract has been reduced from 50 years to 25 years. The cash flow upon which you have borrowed has just been reduced from 50 years of cash flow to 25 years. I don't think I can be clearer in terms of deprivation than that. So, well, some would say, but the benefits, the financial benefits that the government received from mining is not that great. So it's like, that's why you don't have support. Then that's an issue that we must address. I think the mining industry has accepted and is prepared to work with the government in arriving at a fair share with the government, for the government as far as mining is concerned. So it's not, when the issue is fair share, then let's address that. Let's not talk about imposing unreasonable restrictions or closing, or even talking about closing the Philippines or certain areas to mining. Let's address the issue as they are. So let's focus on it and not expand the issue. So, well, as a final note, I'd just like to say, modern civilization as we know it depends on mining. Modern technology that powers machines and innovations, including those that protect the environment, depend on chemicals, metals, and alloys that we mine. Modern medical machines that give helpless infants a chance to live and that prolong the lives of our loved ones are all dependent on mining. If this is the inconvenient truth, then we must accept that mining is here to stay and that proper regulation of responsible mining is the only way to go.
Good afternoon, ladies and gentlemen. Thank you, Marilyn. You have 4 lawyers on the stage. You have an economist, and you have a mining engineer, a PhD at that. I'm just reminded about the story of St. Peter, where you had a mining engineer, an economist, and a lawyer at the pearly gates of heaven. And St. Peter told them that they had to pass a test before they could go in. and he was asking the economist, name the ship that sank on its maiden voyage. And the economist said, oh, I just recently watched the movie. It must have been the Titanic. So he was allowed in easily by St. Peter. And then the mining engineer was asked also, okay, Mr. Mining Engineer, how many died on the Titanic? And the mining engineer said, oh, must be, that's a tough question. But I think it was 1,500 that died. Okay, that's good. You can go into the pearly gates of heaven. And then finally the lawyer was asked, Mr. Lawyer, you're a litigator. Can you tell me the names of the 1,500 who died? So that question, I suppose, is a question posed to the reactors for this plenary session as well, as to how we can come up with an observation on the issues that were discussed for this plenary session. And I must say it was a fairly tough job to do, given the qualification that the first speaker said, that his talk could not be related to EO 79. But with due respect to our Assistant Director of the MGB, I must say that it is difficult for us to deviate from the topic of EO 79, precisely because the three speakers actually had to touch on EO 79 unavoidably. In particular, the first speaker, Dr. Biledo, told us about how the MGB addresses climate change. And I must say that it's, with due respect, one way of addressing climate change is to also resort to a policy change with the EO 79 adoption. So the second speaker also spoke to us about poverty environment initiative and enhancement. And I must say also that poverty reduction was one of the issues that was addressed or is trying to be addressed by EO 79. And you had our impassioned speech by our Attorney Lombos on the seeming unconstitutionality of EO 79, plus the environmental rules of procedure, which he says also is unconstitutional. So there is in fact a common thread, as you have seen. There is a relation to EO 79. And in my other role now as a panel reactor, may I just commence on the question and answer by addressing this first question to Dr. Biledo. And I would refer you to two sections of EO 79, which is section, or a particular section of EO 79, which is section 16, where there is an integrated map system to include mining-related maps. I did listen to you earlier, and one of the issues in relation to climate change is that the MGB is preparing geohazard maps. My question perhaps to you, Director Biledo, is how this would be related to the declaration by MGB as well as the DNR of additional areas to be close to mining, and how you foresee this to be done in the near future. And perhaps the question I ask also to Mr. Mayor is, given your analysis or evaluation of how the mining sector is a partner in the poverty alleviation or reduction program of the UNDP, may I ask how optimistic you are insofar as the mining industry and government are able to face the challenges that UNDP has posed in respect of poverty reduction. And finally, perhaps my question to M. Lombos, it would be that given your analysis of the unconstitutionality of what seems to me is a judicial legislation in the form of the Supreme Court enactment of its rules on environmental procedure, as well as the executive legislation by the issuance of the Philippine President of EO 79. If you were to be consulted by the chamber or the mining industry, how do you think this constitutionality issue, which appears to be, as you had argued a while ago, to be very valid and should be raised as a concern. How should the mining industry approach this?
Thank you very much, Attorney, for that question. Actually, it is within the mandate or the directive for the NAMRIA, the National Authority for the Mapping, to come out with a national or a very comprehensive map on the different areas. For example, the tourism development areas, the protected areas, the agricultural lands, and also to come out with the what we call the approved IPs community. They should be well mapped, as well as all the parameters should be there. For the MGB, we have the geohazard map identifying areas that are prone to landslide and flooding. Actually, the MGB's geohazard mapping program is about saving lives. So, for example, for a community that is prone to landslide or flooding, we look for or recommend areas for resettlement. So we have to study the area and look for better and a safer place for the community. But for a mining application, for example, that is categorized as high or moderately prone or susceptible to landslide, I think this will not be included in the areas close to mining. We actually make recommendations for the mining companies to take extra caution, for example, to these areas identified within their application, that so that the earth-moving activities will not put in peril the lives of the communities or the residents living in the communities. And also we recommend that they put in place mitigating measures to protect their operations and the communities as well. These areas classified as high will not be part of the areas close to mining. Thank you.
Yes, thank you. I am optimistic, maybe a bit by nature, otherwise I wouldn't do my job, but as long as we don't give decision power to people like Attorney Lombos, who have such skills to demonstrate that A plus B equals C and C minus B equals A and vice versa, because he could have us agree and convince us about anything with the legal skills that he has. So on that side, I'm a little bit less. But I think seriously, the long-term objectives of both government and business is the same. In today's world, even if the business starts from a perspective of making money out of an investment, and the government's job is to ensure the well-being of its compatriots and its citizens, one doesn't go without the other. So I think there is a rationale for both stakeholders to find grounds and a compromise whereby investments are going to be sustainable and long-term and for the benefit of the communities. And this is the first and foremost objective, and sometimes we have to stick to ideal politics. But even in the Philippines, I think it's still very much what drives government. And we see it, and if I just had to take one example, in the overwhelming support of both the business and the government on support to the ITI. I think just taking that as an illustration, there's been from the very beginning a clear understanding that it is in the benefit for both the legislator and the private sector to ask for a conducive legal environment where transparency and where principles of accountability are what prevails over the industry. So just for that, on the basis of that assumption, I think there is good progress on that front, and no EO will ever be perfect, especially when given to lawyers for analysis. But I think beyond that, one doesn't always need a lawyer to know whether what we do is right or wrong when we think of moral values and benefits for the poor.
I'm a little litigation lawyer, but I don't like being one. Especially in this country where you have all the problems affecting the judicial system that you do. So my advice to clients, not only because I don't like what I do, but Because the reality on the ground is, in this country at this time, if you find yourself in court, you're already a loser. Even if you win after 10 years, you're already a loser. And if you lose after 10 years, you're doubly a loser. So the basic, fundamental, and soundest litigation advice that I give to clients and I give to the industry is, don't. If you can avoid it, if you can find any way at all to solve your problems without going into litigation, take that route. Now, having said that, if you are now faced with a situation where all the other avenues have been closed to you, well, no, let me backtrack a bit and say what I think might be done before you get to that point. As far as the first set of rules, which are the environmental rules, there's a special issue you should deal with there, which is that they were generated by the Supreme Court. And if you challenge them before the body that generated them, you're not likely to get a very sympathetic hearing. Just because humans don't like being told that their work product is defective. I mean, that's natural. So I would advise that in that case, there may be a chance for a re-examination and a revisitation of the rules because you have a new Chief Justice on board. These rules were adopted at the time of Chief Justice Renato Puno, and perhaps there may be a less, how do I put it, less invested attitude on the part of the members of the court at this time, and a willingness to review the rules. And so the first step probably in that direction is to make representations with the members of the court, with the Chief Justice especially, and perhaps the group that's responsible for some ongoing reviews or monitoring of how these rules work on the ground, to try and convince them that perhaps some tweaking is necessary. If that fails, then it depends on the seriousness of the crisis that you're faced with, which would, at the end of the day, determine whether you have to go to court or not. But if, well, then let's move quickly now to the EO 79 and what I would advise you to do in this case. Well, the same thing. Continue to make representations with the executive branch of government. Do not give up on efforts that have not succeeded so far. You just do not have a choice but to try and keep exhausting those efforts, keep knocking on doors, and hope that at some point you find the way to deliver the message that gets through to somebody who can make a difference. Now, if that fails, or you're overtaken by events and a crisis is afoot, and you have to sue, or maybe even, well, this is, in a sense, already a crisis if you don't get things resolved in a friendly manner and the rules remain the way they are for some players in the industry, or maybe for the industry as a whole. So if a case needs to be brought, I would suggest you find a broad-based coalition of stakeholders and not just the chamber. You will have to define to your publics and to the government that it is a widespread view that you're promoting and not a self-invested view only of the players within the industry. So that recommends considering even or especially the members of the indigenous peoples who might feel that they are themselves hurt by some of the provisions of the EO. People in the professions, geologists, mining engineers, etc. The second thing is you must frame your case so that it's very clear that it's not a matter of sour graping or nitpicking that motivates you, that it's a matter of basic, fundamental, unavoidable fairness, and maybe even, if you can manage it, survival that brings you to court. And it must be an effort that you're able to sell to your publics that is one pursued for the good of the country. Our courts are not the impervious, blindfolded dispensers of justice of myth and legend. They are real people who live and work within the same communities that we function in. So they hear what's going on and they're influenced by what people say. So you must win the public debate in any event.
Thank you to our panel and our discussants. We will now take questions from the floor. We have approximately 20 minutes left for questions. Please identify yourself and kindly keep the questions brief so that we can take as many as we can in the remaining time. Yes, sir.
Thanks. My name is Rolly. I am from BMP Environment. I like the thesis propounded by Attorney Lombos. Let me just enrich it a bit, or perhaps add more to the debate. No? Now, you mentioned the right to, to property, due process, etc., fair rights. I think we should balance that with Section 16 no, of the Constitution, which I'm sure you're very familiar with. The right to a balanced, take note of the word balanced, and healthful ecology in accord with the rhythm and harmony of nature. No? So as lawyers, you will have a difficulty dealing with that, defining that in pretty clear and quantifiable terms. Even as technicals, we cannot define that as well. Even healthful ecology. That's why I think that gave rise to the precautionary principle no, in environmental management. This Silent Spring, Rachel Carson, no? The PCBs, which at the time were not discovered or were not known to cause ecological problems. So that's why they insisted on, for those circumstances wherein people can show some damage, but without being fully scientifically certain about it. Because science requires a rigorous process of toxicological assessment, which in certain cases we don't have. No? So in that particular case, that's why it gave rise to the scientific uncertainty. They relaxed it, but I think we should, if we will not do away with that, I think the court should have a more pragmatic implementation of that. No? That there should be a real honest-to-goodness assessment of whether there is indeed, that damage, which justifies the precautionary principle. But if it's just a couple or a group of IPs complaining that their water is being impacted and coming up with everything, but they can't really prove it, so I think that case should prosper into a TEPO. No? Now, on the last point is. You mentioned EO 79 as being abrogating certain, legislative functions. I think you have also to look at Department Administrative Order 96-40, where in Section 15 of that DNR, this was issued in 1996, no? They included a provision there, areas close to mining application, areas which the Secretary may exclude, based inter alia on proper assessment of their environmental impacts and implications on sustainable land uses, blah, 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 with appropriate barangay, municipal, city provision, sangguniang ordinance, specifically through, et cetera, no? So it's there, no? Way back 1996, they did it. So they're doing it again, EO 79. Thanks.
Would you like to take?
Oh, well, just a short response. I agree with what the gentleman has said. My own appreciation of the precautionary principle is that it's a principle that is best adopted for policy making and not for judicial decision making. Because when you're defining policy, it is really your duty and your call in areas where things may not be so clear to define policy in a conservative way. That's fine. But where there is an actual conflict involving an actual intrusion into property rights, the Constitution does kick in because of the basic guarantee for substantial due process. And there should be a showing, somehow verifiable by some kind of preponderance of facts demonstrated to the fact trier that the fellow applying has a right because there is a real threat to his activities by the manner of your use of your property.
Next question. There are no more questions or comments from the floor? Yes?
I think the Constitution is very confusing. You said the President had an oath of office to defend the Constitution. Now, the MICC guys made recommendations. Are they aware that they're going against the Constitution? That's what you said. This is unconstitutional. Do they know that? If they did, why did they still recommend it? And then later on, we don't know. The President just talking to the bottom line, and then we're lost. The 50-25 number is very serious.
Well, my understanding, and in fact I do know, that the Chamber and members of the industry made earnest presentations to the MICC regarding not only the issues I presented to you, but a host of other issues which the Chamber and the industry sincerely felt were of, at the very least, doubtful validity and in some cases clear questionability. We are as equally puzzled as you are why the measures that are in the EO and the IRR remain in the state they're in, notwithstanding those submissions.
If I may just add to that, there were consultations, but these came quite late in the day. In fact, there was a round of consultations on one day, Friday, September 7, and by Monday, the rules were approved, the IRR were approved by the MICC. So that's perhaps another angle to look at. Any more questions or comments? You would like to go to the cocktails now. Just before I close, our panelists made mention of the IPs also and the right to self-determination. In an earlier panel, Attorney Leo Dominguez also spoke about that. And I would just like to invite you to our booth, and I will give the floor to Philip shortly after this brief advertisement. The booth of Diwata Women in Resource Development, because we hosted a dialogue on the views of IPs and women on EO 79. And at our booth, we are playing excerpts from that dialogue and have prepared a summary which you may want to read. And in case you would like to hear more about what the IPs have to say, and they are very passionate about this, there's another opportunity on November 15 on the occasion of the PMSEA conference in Baguio. Yes, Philip.
Yes, I just have one question. We heard a lot about how certain actions by the DNR Secretary to sign the Dow EO 79 IRR. We heard about certain statements made by the DNR Secretary that Philex Corporate Affairs Mike Toledo raised. The question is, what legal liabilities does Secretary Paje expose himself to by these actions?
No takers for the question. What liability has the Secretary exposed himself to? Signing of the EO and the Philex statements. Philex.
Well, well, I'm a director of Felix. So all that we can say, and I think we've said this, is what the incident that happened is force majeure. And Felix is entitled to due process, notice and hearing, and it is certainly not to a trial by publicity. Certainly, due process does not, it is not due process when you hear about the charges and about the penalties from the media and you have not received any copy of the allegations before your regulator goes to the media. So that is our main concern in that respect, no? What is the liability of this secretary? Well, we can certainly question the manner under which this, the penalties are being discussed in the media without giving us due process, because we are a listed company. We have stakeholders, and they get nervous when they hear about billions in fines, and then we are not given a chance to defend or to present our story. So that is, I think, again, going back, this is simply a fundamental right that we are asking. A fundamental right to notice and hearing and to due process. That is not too much to ask by a company that is undergoing so much difficulty because of a situation which is not within its control. It is force majeure, and we never turn our back on our responsibility to do rehabilitation of the environment, notwithstanding that this is a force majeure situation. We've been very honest, we've been very frank. In fact, we've told our regulators, don't worry, we will do the right thing in this. We will do the right thing, we promise you that. And all we ask is due process. That's not too much to ask.
Philip's question is as difficult as the question of St. Peter to that lawyer, I suppose. But nonetheless, let me try to hazard an answer for you, Philip. I think there's still a presumption of regularity in government officials' actions. So until it is officially questioned before a court of law, in connection, I suppose, with questioning the constitutionality, in fact, of EO 79 and the IRR itself. Only then, I think, can you come up with a situation where you actually question the actuations of a government department secretary.
Yes, Ernie.
Ernie Ordonez. I belong to the largest NGO group in the country, Alianza Agricultura. I'm the chairman. But I'm also the head of cement manufacturers here, and I was the head of 8 countries doing cement, so I know both sides. I'd like to comment, even though you want to go to the cocktails, I want to comment on the wisdom given to us by Attorney Labos. Right? He said, before you litigate, let's do something before that. So when we ask about legal liabilities, I think they'll put the fear of God on some people. But before we execute that, let me say the following. I was an undersecretary and a secretary under 3 governments. I fought Volante, so I was kicked out. But I kept my integrity. And it is with this integrity that I will now make a plea. On September 7th, my group represented a non-metallic sector, and we gave suggestions. On September 10, not even 2 days after that, I saw the IRR. The question is, did the IRR reflect the consultations? Now, having been a former bureaucrat, though the majority of my life was a businessman, I would say this. Public-private partnership under President Noynoy Aquino means that there should be unity and communication, right? Now, I know from government that when government hears the private sector side, sometimes they don't understand it and they write it down. And they think that's it. I'm a believer in continuous revision. This is the first attempt they've done to capture the insights of September 7. And as you yourself have seen, the consultations were pretty late in the day. However, the beauty is that we have 15 days before it becomes effective. I talked to the NELA secretary today. I said, when is the 15 days? It is when it is published, so count the days. In our democracy, we still have time to change the IRR. My plea is this. My plea is for DNR to be humble and open yourselves to possible recommendations for the IRR following Attorney Lombos' suggestion. What I do not like to see is that we get too involved in this and say, this is it and you ain't gonna talk. Because if you're gonna do that, it will be a failure of what President Noynoy Aquino wants. He said PPP. So I'm just saying this, as a participant in this, I believe in the balanced view. I do believe that there are some things that we should correct in mining, definitely. But I also believe in the advantages of mining. And I believe that MICC, having gotten second-hand information for the consultation. Second-hand, they weren't there. They weren't there. I mean, Goson was there, Acosta was there, but Purisima was not there, di ba? Balisacan was not there, Singson was not there. They get this, right? I plead to Assistant Director, whom I've interacted with, whom I respect greatly. I plead to Leo El Sereno that we do not go and say, we're going to go through the 15 days and see you in court. That is not what President Doña wants. What I'd like to do now is let the EMB, DNR, MICC look at the suggestions that came on the version that they did 3 days after consultation and see whether we think our ideas were reflected. Do you know why I called up a few times after that? I said, wala yung sinabi namin doon. Actually, meron dyan, ganito interpretation. Right? But we prefer that that interpretation, if it is really true, be right in the IRR. Because if it's not there, as Attorney Bunya told me, I've been talking to her too, if it's in a side agreement, you don't know. You know, our investors are going to Europe and they're saying, we want this. If they insist on certain things, we will lose it to China and other countries, correct? And yet, in my heart of hearts, I know that the MICC, Purisima, Balisacan, etc., are on our side, right? It's just that the IRR did not completely capture it. So, in summary, Attorney Lambos, I think they should listen to you. I think EMB should now open itself to the suggestions coming in and not say, tapos na yan. No, they should open themselves. And we got 15 days, and opening themselves, they must make the minor corrections. Because, let me repeat, having been a bureaucrat, when we hear the private sector say something and we write it down, we often make mistakes. What we should do is, we write down, give it back to them, and ask them to comment, right? They're actually doing that by giving us 15 days, right? But this time, we want them to be sincere. And we want them to look at that input and follow what Attorney Lombo said. Look at it. Baka meron hindi nahuli doon. And change it. What I do not wish to see is that exact same thing is gonna go in and be published because people are ego involved, right? We should not be ego involved. The country's at stake. And I think given that, Attorney Lambos, I hope EMB and we, let's not be skeptical here. Before we jump to court, let us assume good faith. Let us give our suggestions, not only in a form like this, let us make it formal. Let us talk to MICC members, because I'm doing that myself. I'm talking to Balasacan, Singson, etc. And let us hope that the changes that have to be done are done, and the September 10 document gets the correct amendments before we rush into a fight. Thank you very much.
Okay, with that, I think that is the last word on this topic. And see you all at the cocktails where we can continue to discuss all these issues. Thank you very much and good afternoon.
Thank you to our session chairwoman, Attorney Patricia Bunya. Thank you to one and all, and we look forward to continuing our dialogue at the cocktails following shortly at Snap Sports Bar at the lobby level here at Sofitel.